Yes, good afternoon.
Hello, it's my lady. We're going to finish conflict today. I think we're confident as to meet compared notes, so to speak. I was going to move on to the second issue. Now, if you're with me on everything this morning, we don't get to the second issue. Sorry, Lord Justice, because if you might ask me something I avoided last
well, I have got a couple of questions for you, but I don't want to. First thing I want to ask you is this. On your analysis, in relation to a dividend paid by a company which has suffered a wrong, the dividend is lower because of the wrong. Mm-hmm. On your analysis, that would be an avoided loss.
No, I'd say the reflective loss principle would block it. I'd say the principles in Marex would apply to block that because the person who's holding the share is an existing shareholder and therefore has a unity of interest with the company, has to follow the fortunes of the company, and if the company brings its own action, then that person who received the lesser dividend will nonetheless benefit from the damages.
I see. So avoided loss is dependent upon whether there's reflective loss.
Sorry, in that circumstance, there wouldn't be an avoided loss.
Why not?
Because of the way that the company is treated as a unity with its existing shareholders. So when you're looking at whether there's an avoided loss or not, one would have to take into account the fact that lower dividends had been paid with the fact that the company would be compensated in toto and that the person who had received a smaller dividend would benefit from that in the future. So, for example, the damages which are recovered might go to making up the difference in the dividend.
Forgive me, but when you're arguing in relation to the shareholders who redeem, one of your arguments as to why it isn't reflective loss is because the company has avoided the loss.
Yes, I understand that.
But now you're saying if it's reflective loss, then they haven't avoided the loss. So it's completely circular.
No, because when you've got an existing shareholder, the interests are a unity. So let's take it in the timeline. The existing shareholder receives a smaller dividend. The company sues for damages and recovers for its loss. The company then pays out higher dividends next time because it has recovered the damages that were reflected in the previous dividend.
But none of it's avoided the loss.
But it's not an avoided loss if you look at it as the unity and you look at it over time. Because it will, on that basis, it will make up. When the company receives compensation, as Lord Reid explained in Marex, the company is compensated, but so are the existing shareholders. So the assumption on that basis is that whilst the lower dividend is paid out, when the damages are received, those damages will go to compensate the lower dividends in the future. So there is no avoided loss. Not if you look at it in total in that way.
Right, I understand, thank you.
So if you're with me on everything I've said to date, then the strikeout must fail. If you're against me of what I've said to date, we come to the second part of the argument. So we're imagining now a situation which is insofar as the appellant's claim is based on Article 101 TFEU, if domestic law does not provide a cause of action to redeeming beneficiaries under company, trust or partnership law, that raises the question of whether domestic law is compatible with EU law. And if it's incompatible, that then raises the next question, which is what should happen after Brexit. So two questions arise. Is there a conflict? And what should happen? Now, our submission is that under Article 101, any person who suffers loss as a result of an infringement of Article 101 has a right to claim damages. And the appellants submit that it is for domestic law to decide who has standing to bring a claim for damages in respect of a breach of Article 101 TFEU. So those are the battle lines. If I go back briefly to Courage and Crean, it was well travelled yesterday. It's Authorities Bundle 6, tab 55. And if we can go to page 1624, bundle reference. Now, you may have got the impression yesterday that the principles encouraging cream were some sort of backwater of EU law, but the truth is that the principles which one sees in paragraphs, particularly 19 to 24, are the absolute touchstones of EU law. I mean, these are like the 12 commandments of EU law. The cases that are cited, Van Genten, Loos, Costa and Enel, BRT and Saban over the page, Simmental, Factortain. These are the absolute bedrock of the constitution of EU law. So this is not an authority out on a limb, and I'll show you some further authorities to make that good, but these are absolutely fundamental principles. Can I ask you first of all to read paragraphs 19 and 20, please?
Yes.
So you'll see that paragraph 19 is making the point that EU law is not simply a system of public international law, but it's a law which also applies to and governs individuals, i.e. the nationals of the member states. And then if you can please read paragraphs 23 and 24. And you'll see there that what the court is explaining is that Articles 85, now 101, and 86, now 102, produce direct effects in relations between individuals and create rights for individuals, which the national courts must safeguard. And that's the fundamental notion of direct effect. EU law creates rights for individuals, which national courts must safeguard. And then they say it follows at paragraph 24 that because of those rights, it follows that any individual can rely on a breach of Article 85 before a national court. So that's the system. Paragraph 19, EU law creates rights for individuals. Paragraph 23, Article 101 creates rights for individuals which national courts must
That
protect.
would apply to a current shareholder.
I'm going to come to that. It doesn't in our submission because, as I'll show you,
Why wouldn't
I'm going to show you case law which explains why the rights of current shareholders are protected under the scheme. But I need to show you a couple of extra cases.
But you're placing emphasis on the words any individual.
I am. My submission is that
So it means any individual except some individuals.
No. I'm going to show that a current shareholder has indirect rights to protect itself, to vindicate its rights, and that is sufficient according to the case law of the Court of Justice. I'm going to take you to a particular case that shows that.
So rights includes indirect rights.
That's right. Sorry, indirect rights to protect oneself. Yes.
Well, so does the former shareholder.
No, the former shareholder, unless he has a claim in his own name for the loss that he has suffered, cannot benefit from the company's claim.
But he has an indirect right. Sorry.
Yes, sorry. Well, he could have done in the period until he...
Except he had no actionable loss in the period until he redeemed.
He had an indirect right for the diminution in his value in the shareholding.
Except, well...
by controlling the company or the partnership.
Yes, yes, but not as a former shareholder. When my submission is that a new loss arises, up until the time of redemption, there is no separate loss from that of the company.
But that was the same case. That's the same case with current shareholders.
Well, can I show you? I have to deal with this. I understand that. So what I'm going to do to deal with it is I'm going to show you the EU case law and what a national court is required to do. And I'm going to show you, go back to the Irish case to show the way in which those rights can be protected. So I understand I have to deal with those points, and I will deal with them, but I need to deal with them in sequence if you permit.
But you would say that not only do shareholders who have redeemed their shares in the claimants have a claim, but so would shareholders in the shareholders who redeemed, and shareholders of the shareholders of the shareholders who redeemed.
Logic of EU law is that anyone who has suffered loss as a result of infringement of Article 101 has a right to claim. Whether they can prove that loss is another matter in practice, but that is what EU law provides, yes.
I realise this is probably way outside the frame of this appeal, but where's the effectiveness of that? I mean, if loss is spread through many people who have absolutely no real chance of achieving compensation for it, because little man against bank is not going to get very far.
That argument has not prevailed in EU law. So, and that's the reason.
Where's the effectiveness of the remedy in that case?
And that's the reason why, for example, in the UK we now have the collective proceedings regime, and that's why also in the context of EU law there is provision for the member states to adopt collective proceedings regimes, but precisely because of that practical point that my lord has raised. It's all very well to say everyone has a right, which is the bedrock, but is that going to ensure in practice that there is effective
that's a different
protection?
Question.
And that's why
a different question.
It is, yes. But I'm absolutely clear that the EU law requires that anyone who has suffered a loss as a result of breach of Article 101 has a right to claim. That's our submission. I don't shy from that. And then paragraph 25. You see about 3 lines down. The national courts, whose task it is to apply the provisions of community law in areas within their jurisdiction, must ensure that those rules take full effect and must protect the rights which they confer on individuals. So again, must protect the rights that individuals enjoy. And then 26. The full effectiveness of Article 85 of the treaty, and in particular the practical effect of the prohibition laid down in Article 85(1), would be put at risk if it were not open to any individual to claim damages for loss caused to him by a contract, which is the case we're looking at in Korean, or by conduct liable to restrict or distort competition. So paragraph 26 isn't tied to contractual cases. It is a statement of general principle applicable wherever there has been an infringement of the relevant rule. And paragraph 28, there should therefore not be any absolute bar to such an action being brought by a party to a contract which would be held to violate the competition rules. And then, as Mr. Mitchell showed you, the court went on to consider the ex turpe causa principle and held that that could be applied in a national court where the contracting party didn't bear as much of the responsibility for the restriction. So that therefore was a partial bar. In some circumstances, a person wouldn't have a claim, but it was not an absolute bar. But the fundamental principle is anyone who suffers loss as a result of an infringement of Article 101 has a right to claims. Now I want to go to 2 more cases just to flesh out how EU law applies. First of all, the Unibet case. Its authorities, tab 6, so this same one, at tab 56, page 1661. And could I ask you to read paragraphs 38 to 42, please?
Yes.
So what one gets from this is paragraph 38 is what we saw in Crean about the obligation to protect individual rights. What one sees in 39 is that where procedural rules haven't been harmonised by EU law, then the national courts are entitled to apply their own rules, provided that those rules ensure the effective protection of the community rights. And then at 40, it says that EU law is not intended to create new remedies in national courts. But 41 is the crucial paragraph, except it would be otherwise only if it were apparent from the overall scheme of the national legal system in question that no legal remedy existed which made it possible to ensure, even indirectly, respect for an individual's rights under community law. So in other words, when one is looking at the obligation to protect rights and the power on national courts to apply its own rules, it is the obligation to protect the rights of individuals which prevails in EU law. So that's the first point one gets from this. And the second point is that the obligation to protect rights may be satisfied even indirectly. The next case I want to take you to is a case called Mono Carr Styling. It's at tab 58 in this bundle. If you could turn please to page 1779. I could ask you please to read paragraphs 48 and 49. And what this confirms again is that the obligation to protect EU law rights prevails over the ability of the national legal system to establish procedural rules. So 48 reminds us of the power of the national legal system to set its rules. And then 49, whilst it is in principle for national law to determine an individual's standing and legal interest in bringing proceedings, community law nevertheless requires, in addition to the observance of the principles of equivalence and effectiveness, that the national legislation does not undermine the right to effective judicial protection, i.e. the principle of national ability to set the rules must give way to the obligation to protect the EU law right. That is always the core. Now I come to the point you asked me about, that Lord Justice Phillips asked me about. The appellants say, quoting from their supplementary skeleton, paragraph 32, they say, the respondents now appear to accept that if their submissions were correct, current investors and funds taking the form of companies, trusts and limited partnerships, and not only former investors, would be entitled to sue. And we do not accept that as correct as a matter of EU law. First of all, as indicated in paragraph 41 of Unibet, some national remedy must exist which makes it possible to ensure, even indirectly, respect for an individual's EU law right to claim damages. And secondly, under English law, current investors do have a number of indirect remedies to protect their position. For example, by requiring the investment fund to bring a claim, or, where it's possible, by bringing a derivative action on the part of the investment fund. And in such circumstances, EU law would not require current investors to have their own direct claims for damages. And that is, in fact, what happened in O'Neill and Ryan, the Irish case. I can take you to that. It's in this bundle. It's behind tab 61. And if I can ask you to turn, first of all, to page 1837. you were shown yesterday that on the facts of this case, the plaintiff, i.e. the person who had sold his shares, because this is a case where the plaintiff had sold his shares to another party. It's not a redemption case, it's a sale of shares case. So the claimant, the plaintiff who had sold his shares, had already issued a petition under Section 205 of the Companies Act, as a result of which certain other persons bought his shares. And then at page 1840, the judge, Justice Blay, held counsel further submitted that even though the damage was primarily to Ryanair, the plaintiff, i.e. the selling shareholder, nonetheless was entitled to sue, but he was unable to point to any authority for this proposition. I'm satisfied that there is none. What was being submitted was that a shareholder in a company has a personal action in respect of the reduction in value of his shareholding resulting from damage to the company against the party who caused such damage. Such a proposition was rejected in Prudential. Now that's consistent with paragraph 61 of Promeo, where Lord Sales, given the judgment of the Privy Council, said a shareholder who sells his shares cannot avoid the reflective loss rule. And I've explained why redemption is different from sale. Then at page 1841, over the page, there is a citation from Prudential. And then the judge says this: in my opinion, that is a correct statement of the law, the statement in Prudential, in regard to the status of a shareholder in a limited liability company. What is also a relevant consideration, in addition to the matters referred to in the two passages cited, is the consequences which would flow from giving shareholders in a company a personal action against a party causing damage to the company. It would enable a multiplicity of actions to be brought and deprive the company itself of the ability to control them, so it would be both harmful to companies and very much against the public interest in opening the door to irresponsible litigation. For these reasons, also I'm satisfied that a personal claim by shareholder should not be permitted. So that's really just confirming the judge confirms with Prudential, with the reflective loss rule. And then I'm satisfied accordingly that even the plaintiff was still a shareholder in Ryanair, he would have no cause of action against the last four defendants. Before sure, he has none, since he is no longer even a shareholder. But the facts of this case, it was a sale of shares, it was not a redemption. The Irish court did not look at the redemption issue. And then at 1843, under there's a citation from an ECJ case called Marco. And if you could please read the paragraph that begins in the present case to the end of that paragraph. Our submission is that, as you've already heard from me, a redeeming shareholder does not have those rights. The loss suffered by the redeeming shareholder only arises when it leaves the company, when it redeems, and thereafter it does not have any of these indirect rights. And therefore, the only way in which a redeeming shareholder can obtain relief for the loss caused to it is through an action for damages for breach of statutory duty brought in its name for its loss.
So there's no distinction at this point on that between a selling and redeeming?
In the Irish case?
Well, in general. In both cases, that somebody who has ceased to be a shareholder can no longer use the indirect routes to cover their loss.
Yes.
There's no distinction.
But in the difference between a selling case and a redeeming case is the one I referred to earlier, which is the fact that there would be double recovery if the person who sold the share, well, I'd prefer to put it at the double recovery point, which is that the person who sold the shares, if they had a cause of action, and the company had a cause of action.
But it's only
company-
not double recovery in the case of redeemed.
My lord, sorry,
Because
there is no avoided loss in that circumstance because the company isn't required to give credit to the tortfeasor for the sum that was suffered by this person who sold the shares. The person who sold the shares will have received less, but that is not something that the company has to give credit for in relation to the
Yes, for cross
tortfeasor.
purposes, I accept that.
Right?
In the case of a redeeming shareholder, there are two limbs to this, aren't there? There's the question of the company's loss, whether it's redeemed or not, whether there's double recovery,
Yes.
so whether it's avoided or not. Put that to one side. We're now looking at your second limb, as it were, which is no effective remedy.
Yes.
And as far as no effective remedy is concerned, there is no distinction between the remedy available to a selling shareholder and a redeeming shareholder. And they're absolutely in the same position.
Well, except in relation to the selling shareholder, they are not considered to have suffered any loss distinct from that of the company. In relation to a redeeming shareholder, they are in our submission, they suffer a loss distinct from the company at the point of redemption.
Right.
So prior to redemption, they could not have, if they asked the company to take action and the company had got damages, then the person as an existing shareholder would have got the benefit of that. But on our
But that's the case. In both cases, we're talking about people who were current shareholders.
both cases,
They were shareholders.
yes, a seller and a redeemer.
Yes, and each of those could have exercised their rights as shareholders to procure that the company brings a claim, and they would have been made whole by the company recovery. And in each case, the shareholder has ceased to be a shareholder and so has lost. In each case, their loss crystallises at that point, and in each case, they lose their rights to bring a claim for that loss. The only distinction between the two situations is that in one case, it is the company who has benefited through the sale rather than a third party.
So in
The company gets the benefit of a lower price on redemption,
But not
rather
on
than
sale.
third party.
but not on sale. That's
Not
right.
on sale.
That's right.
That's the only distinction between the two situations.
That's correct. I think that's correct.
Yes. And so, as far as remedy is concerned, there is no distinction. In both cases, the loss is crystallised. They both lose any remedy through the company.
Well, in relation to the selling shareholder, the point is that when they sell, up until that stage, there's unity of interest with the company, and the difference is that the person they sell to takes on that unity of interest.
How does that help them?
Whereas
How does that help them?
no, I understand that this is, and I'm trying to draw it. This is the distinction. I understand the point you're making to me, but there is still a distinction in the sense that when a share is sold, the share continues to exist, and the rights that go with that share go to the purchasing shareholder, and that shareholder, if the company recovers, will get the benefit of that. So they have bought that possibility. In relation to a redemption, the share is cancelled.
Yep.
It doesn't
I
exist.
understand the distinction between a share sale and a redemption, but I don't see how the fact that the rights of the shareholder may be transferred to another shareholder in any way is an answer to the point that they, as a person entitled to claim and entitled to a remedy over 101, have lost it.
Well, in this circumstance, on our case, we're assuming that the person who redeems suffers less as a result of the wrong. That may or may not be the case with a person who sells, because the point that was made yesterday, if the company has on
Let's
its...
assume for present purposes they do.
Okay, if they do, I understand the point you're making to me, and you have my submission of what the distinction is. But if... Let me just tease out this thread. If the company has a right to a cause of action, and if the person sells their shares, they will sell their shares taking into account the fact that the company has a right as a cause of action. And the price for that sale will take account of the possibility of that cause of action. And what they're doing is they're selling their right
So
to...
the redemption.
What they're doing is they're selling their ability to benefit from the company's claim to the third party. So in those circumstances, it's perfectly proper that the selling shareholder does not have their own right because they've been paid for that right, and the amount of money they've paid will take account of the cause of action. Because
the amount of a shareholder who redeems, they will be on the basis of net asset value, which will include the value of the claim. The claim is an asset of the company.
Possibly, I understand.
I mean, I think, as far as I can see for my part, it all comes back to whether or not you've avoided the loss. That the company's avoided the loss. The claimant.
I understand, and you have my submissions on that, and it's an important part of our case. I'm not trying to shy away from that at all.
But the difficulty I see with this is this. If you've avoided the loss, Simon, if the claimants have avoided the loss, you don't need any of this.
I understand that, and that's how I've made that submission.
And
That's right.
all these arguments about whether or not, I mean, the banks are arguing that all these parties have got a claim against them.
That's because we made
When you've got a defence, you say, because the claimants have avoided the loss.
Yes, but
It just doesn't seem to make sense to me. Surely the first and foremost thing we should work out is what is the company's loss? Have they avoided it? And if they've avoided it, then you don't need to worry about whether or not, well, you may in future need to worry about it, but we don't, for these purposes, need to worry about whether or not there's a corresponding claim on the part. The only reason we're arguing about whether or not the investors have acquired a cause of action for loss is because that was the understanding between the parties, for Mr. Justice Teare, that was the test for whether there was a pass-on of loss. And it seems to me we've slightly shifted ground now. So the focus has become, it seems to me, entirely on whether or not the companies avoided the loss such that shareholders who redeemed can be said to acquire, well, whether
I understand.
that. And that's stage 2. But it may not even, and we don't need to get to stage 2.
I don't disagree with any of that. So what happened? I mean, we're going to go over ground we had this morning, which is we put forward our pleading, avoided loss mitigation pass-on. The claimants applied to strike it out on various grounds, and the grounds they relied upon were the reflective loss rule, that only the trustee can sue, that only the general partner can sue. They did not seek to strike it out on the fact that this was a collateral benefit. So we then met the arguments that they were relying on to strike out. And that's why we do reflective loss trust partnership. But we also have our pleaded avoided loss case, and you have my submission on it, which is avoided loss does not require a third party to have a right to sue. It's simply a question
It's
of whether...
unusual for a party to be coming to court raising as an argument that it is liable to somebody.
I understand that, but that's the case I'm instructed to put. And it's right or it's wrong. But that's the case we're putting, and that's the case I'm instructed to put. I understand your point. It doesn't mean it's right or wrong as a matter of law that it is surprising. That's for the court to judge. No,
but I can understand there might be circumstances in which it is necessary to do that. But it seems to me you're doing it in a situation where it isn't necessary to do it.
I understand. And that is my submission. I made it to you that even if they are right on their reflective loss trust partnership points, in any event we have our avoided loss argument, and you prefer to take that first for all. I understand that, and you can take it first, and it's the same point, and it has the same effect. Yes.
See Quinn Emanuel maybe having another collective action.
Oh yes, that's my clients are well advised.
Thank you.
There's one final point, which is the second part of this EU argument, which is what is the effect of the Brexit transitional provisions. And Mr. Mistro didn't address you on this. It's dealt with in their skeleton argument, but I think obviously it's important that I deal with it. The status of EU law in domestic law after what's known as IP completion day, which is 11 p.m. on the 31st of December 2020.
IP is interim period.
I should know that off the top of my head.
Implementation.
Implementation. is governed by the European Union Withdrawal Act 2018. So the 2018 Act, I'll refer to it as. You find that in Authorities, Bundle 1, Tab 10. And if we can go, please, to page 153. Section 4. And if you could read section 4.1 to yourself, and here we're concerned with rights. In that list of items, we're concerned with rights.
Is this contentious?
No, I was about to say this is common ground. This is precisely the basis upon which the claimants are able to bring their case.
Yes, understood.
Because the facts arose before IP completion day,
Yes.
so they can continue to rely on Article
Yes.
101. And then the Withdrawal Act, if you go to 155, Section 5, and if you could please read paragraph 2. You'll see that there's a saving in relation to the principle of supremacy after IP completion date.
I'm sorry, which section?
So section 5 sub 2. And our submission, what that means, because supremacy is saved, insofar as this court were to find that the common law imposed an absolute bar on the ability of redeeming shareholders, beneficiaries, etc., to claim damages for losses caused by breach of Article 101, the rule of supremacy would require that common law rule to be disapplied to give effect to EU law. Now this is where we start to run into difficulties, because the Act does not contain a definition of supremacy. And there is no definition of supremacy in the treaty. And I haven't done an exhaustive search of every case the ECJ has done, but the ECJ doesn't use the term supremacy. It's a shorthand term of art that is used by EU lawyers in the textbooks, but it reflects principles in the case law which themselves do not bear that label. So I'm going to come to what I submit as the scope of supremacy. If we could look at section 5 sub 6 on the same page, you'll see it says Schedule 1, which makes further provision about exceptions to savings in the corporation has effect. And if we go to Schedule 1, paragraph 3 sub 2, that's at page 183. So paragraph 3 sub 2, no court or tribunal may, on or after completion day, disapply any rule of law, which would include a rule of common law, because it is incompatible with any of the general principles of EU law. And you're probably not going to be surprised when I tell you that the Act does not contain a definition of general principles. So the Act draws a distinction between supremacy, which can be relied on after IP completion, and general principles, which cannot be relied upon after IP completion day to disapply a rule of law. We are, however, assisted by the explanatory notes as to the meaning both of supremacy and general principles. And we find the explanatory notes in Authorities 7, tab 65. So you'll see the front page at page 1948. And if I could ask you to go to page 1953. And if I can ask you to read paragraph 59, and the punchline is that the general principles referred to in the Act include the principle of effectiveness. And then if you look at the footnote 18, under the principle of effectiveness, it must be neither practically impossible nor excessively difficult to enforce a union law-based claim, and you've seen that in the case law. But then the explanatory notes refer to impact case C 26806, paragraphs 44 to 46 for an exposition of both the principle of equivalence and the principle of effectiveness. So here the explanatory notes are explaining what the drafter of the legislation understood by the principle of effectiveness. Now, impact, I'm going to come back to Bundle 7 in a minute for those who are in hard copy, but impact is in Bundle 6 at tab 57. And the relevant paragraphs referred to in explanatory notes are at page 1722. And if you could please read paragraphs 41 to 46, which are those cited in the explanatory notes. And you will see from paragraph 46 that the court in this case defined the principle of effectiveness as relating to procedural rules. Now, the principle of supremacy is not confined to procedural rules. It also applies to substantive rules. If we can go back to the explanatory notes, so authorities, Bundle 7, Tab 7, page 1953, it's paragraph 62. You'll see the description of the principle of supremacy, and you'll see that it is in general terms. It applies to substantive rights, and that won't be an issue. And we saw when we looked at both Unibet and monocar styling that the principle of effectiveness is subordinate to the protection of rights. The protection of substantive rights prevails. I showed you those two passages in Unibet and monocar styling. So on the basis of these materials, and this is simply an exercise of interpretation of a domestic statute, at heart, that's what we're dealing with here, we submit that for the purposes of the Withdrawal Act, the principle of effectiveness applies to procedural, but not substantive national rules. Because that's what the explanatory notes tell us. So how does that apply in this case? Well, we've seen it in Primeo at paragraph 55, that the Privy Council held that the reflective loss rule is a rule of substantive and not procedural law. And the same must apply to any rule that would prevent a former beneficiary of a trust from suing or for a former limited partner from suing. Those are all substantive rules. And therefore, if the reflective loss or the trust or partnership rules were found to be contrary to EU law, it would therefore be the principle of supremacy, not effectiveness, that would have to be applied to vindicate EU rights, because those are rules of substantive law.
And you, just so I'm clear in my mind, you argued it the other way around below. You argued effectiveness, not supremacy.
We didn't put the argument in this way, below that is fair, and that's why we've put forward a proposed amendment to our respondent's notice. No objection was taken to that in opening, so that's the basis I'm proceeding on, but that's a fair observation.
Thank you.
So your argument basically is that Brexit makes the difference.
Because supremacy is preserved after the IP. And this is a supremacy case, not a procedural effectiveness case. Unless you have any further questions on the submissions on behalf of my clients.
Thank you very much.
Thank you very much. Thank you.
Give me a moment to organise myself, please.
Yes, take your time.
I'm grateful. Mr. Hoskins told the court that the framework for this, for the issues that arise on this appeal, is to ask, first of all, whether a separate duty is owed to the investor, and secondly, to ask whether the investor suffers a separate and distinct loss from that of the fund. And we don't dissent from that as a framework. Now, in relation to separate duty, he relied on garden cottage food, and he said, well, there's a separate duty. But the garden cottage food point is actually the same point as the Article 101 point. So garden cottage food is about a claim for breach of statutory duty, claiming a breach of Article 101. So it doesn't give Mr. Hoskins any better argument than Article 101. I'm going to come back to Article 101 because we say that he's wrong about the effect of that. So I want to deal first of all with the point about loss. So the allegation that the banks make that the investor, when the investor redeems or withdraws their shares, suffers a separate and distinct loss from that of the fund. Now, taking the position of companies, Primeo establishes that a loss that is subject to the rule in prudential cannot be converted into a separate and distinct loss outside that rule merely because shares are sold. And we say that it cannot be right that whether the shares are sold back to the company or whether they're sold to a third party is material, such that, as Mr. Hoskins seeks to contend, an entirely different legal analysis ensues. So the key issue, as it emerged in the debate that was had, the key issue for this court is whether Primeo can be distinguished on the basis that it was concerned with sales to third parties. And you've heard that Mr. Hoskins says that it can be distinguished, and in the case of a redemption, the former shareholder suffers a distinct loss. So that's what they need to show. And the fundamental difficulty with that submission, we say, is that the selling shareholder, the shareholder who sells to a third party, also suffers a distinct loss because he or she has received less from the third party than they otherwise might have done. Now, Mr. Hoskins said there's a new shareholder who can benefit from the company's claim in the event of a sale. But that argument, we say, effectively concedes the point we make, which is that the company's claim is for the benefit of shareholders as they exist from time to time. The former shareholder who's sold to the third party is not gaining anything in this scenario. Why does it make a difference that there's now a new shareholder who may in fact have bought the shares at an undervalue? Who knows? But it doesn't make any difference to the position of the selling shareholder that they've sold to a third party or redeemed their shares. There's simply no difference in principle. In each case, it can be said that there's a loss in fact, and that there simply is no material distinction between the two situations. Now, this is also a fundamental problem for the banks on the EU law point.
Just moving then,
Yes, just, can you take it a little bit slower?
Yes.
In each case, whether redeeming or selling to a third party, the selling shareholder has suffered a loss in fact. Yes?
My lord, that's so what's being said by the banks is that a new and distinct loss from a distinct loss to that suffered by the company as a result of the wrongdoing is suffered by a former shareholder when they redeem their shares. And they seek that the difficulty for them is that Primeo presents a difficulty for them, because Primeo says that where a shareholder sells their shares to a third party, then that's not to be considered a separate and distinct loss, and you're still within the rule in prudential. And so really what Mr. Hoskins needs to do is show the court, is to persuade the court that there's a material distinction between those two situations. So a material distinction between the situation where a former shareholder redeems their shares and where they sell the shares
Well,
to the
I
third
can
party.
see that from the point of view of the departing shareholder, it may not make any difference whether they sell to the third party or simply give their shares back in a redemption. But the point would seem to be that it makes a difference from the point of view of the company.
I'm going to come to that, my lord. So first of all, it's very helpful, if I may say so, the 2 points that you've teased out. So from the perspective of the redeeming shareholder is really the only perspective that matters for the purposes of the EU law argument, because they're saying EU law confers a right on an individual who suffered a loss. And so from that perspective, and Mr. Hoskins really had no good answer to that.
So from the point of view of the departing shareholder, in whichever manner he departs, it's all too late. He's out of the company, and that's that. So.
And for the purposes, so thinking about the two answers that Mr. Hoskins gave, so for his EU law argument, he says that what matters is that the individual needs to have an effective remedy.
So you say that seen from the standpoint of the shareholder, it's all the same.
That's right. So there's no material distinction.
So the TFEU doesn't is not being confounded by the arrangements, because it's exactly the same situation.
Well, we say that their arguments on EU law prove too much, because they accept that there's no that for example a current shareholder or a shareholder who's sold their shares doesn't have
a long departed shareholder.
Yes. So and so we say from the point of EU law they're in difficulty, because that the shareholder who sells their shares has also suffered a loss, which on their case, the logic of their case, should mean that they should have a right to sue under EU law. Now, from the point of view of distinguishing Primeo, Mr. Hoskins makes a separate point, which is the avoided loss point. So he's got two arguments. The first argument, we say, just doesn't hold any water, because there is no material distinction when one's focusing on the nature of the loss.
I think Mr. Hoskins came close to accepting that.
I think he probably did. I think he probably came close. He didn't explicitly concede it, but he ran out of steam, as it were, when the point was put to him. So,
well, I think he fairly conceded that there wasn't necessarily an answer to the point that they were in the same position.
That's right. So I think the only real basis then, the only point of distinction between the present case and the case in Primeo is the avoided loss point.
Yeah, so the company wouldn't have to give credit, doesn't have to give credit on a sale to a third party, but the argument is does
exactly,
on
my
redemption.
lady. Exactly,
and why is that not a material distinction, do you say?
So I'm going to come to avoided loss.
Right.
But we say, well, I'm going to come to avoided loss, but I just want to establish first that we say that Mr. Hoskins' argument followed exactly the same course for trusts and partnership. So where we're at, in effect, in my respectful submission, is that the entirety of the bank's submissions on the separate and distinct loss point come down to their avoided loss argument, and they assume that their avoided loss argument is correct.
And that's your circular law. That's your circular point.
No, I'm not. I don't think I need to say that it's a circular point, but I just want at this point to establish that is what all of their arguments come down to. And it might be said that that point arises logically first. In fact, it does arise logically first, because if they're right on avoided loss, and we say we're wrong, and they're wrong, and I'm going to grapple with that point in a moment. If they're right on avoided loss, none of this debate that we've been having is of any relevance whatsoever. So the first point to look at is the avoided loss point, and it's the only point. Their argument hinges on avoided loss, and if they're wrong, everything else collapses.
Did that become clear before Mr. Justice Teare?
My lord, no. And can I just...
Why didn't it become clear?
Well, because the argument that the banks proceeded on the basis, you've seen their pleading, so it's fair to say that they separated out mitigation, pass on and avoided loss. But the entire argument before Mr. Justice Teare proceeded on the basis that they're all bound up together and the same thing applies. And we saw that from paragraph 4 of their skeleton argument.
But now when we've been arguing about, we've been effectively going down the same path, but it's become plain in the course of the argument that avoided loss is a key to distinguishing. I suppose you hadn't had the mayor at the first instance. That may be the. That may be.
Yes.
My lord, I think that was. I mean, I hesitate to try and put myself in the shoes of my opponents, but obviously before Mr. Justice Teare, they had UCP and Nectras. We hadn't had Primeo, and they thought they were on pretty firm ground on all of this. So none of these points were argued. Can I just show you another part of the transcript? We haven't had the opportunity to go through all of the transcript, but can I just hand up the transcript from the last day?
I've got this electronically, have you?
Yes. I have it electronically, as does my lady, and I prefer to look at the electronic version.
It's not in the bundle, because...
Wasn't it sent yesterday?
I'm so sorry, the transcript of the proceedings below.
Ah.
Oh, the transcript below.
I'm so sorry for not making that clear.
Thank you.
So can I take you first, before we go to that, can I take you first to what is in the bundle, so the supplementary bundle? And it's the final tab, tab 18, and page 388. Sorry, 338. So, if you have that, could you please look at page 84, so the bottom right-hand corner. And then you see, from around line 17, you'll see, just going back to pick up a point, this is Mr. Hoskins' submissions, I made earlier in response to the question that you put to me, my lord, about if there's been pass-on. Is it our case that the indirect purchaser has a cause of action? Again, you'll see that assumed, it's not in debate, but then over the page, that's the fundamental basis of the regime.
Sorry, page, I've just got behind.
So sorry, page 339 now, my lady, and it's page 85 of the transcript.
Oh, I'm sorry. Yes, thank you. Yes.
And then from line 5, so it follows from this, my lord, that the application of the principles of avoided loss and pass-on do not lead to any party avoiding a windfall as the claimants would have it. On the contrary, these principles ensure that any party which chooses to bring a claim gets what it's entitled to. It's compensation for the loss it suffered, but not overcompensation. And in the present case, the funds have claims for any losses that they've suffered, but equally investors have claims for any losses that they've suffered. So that's the way that it was put. And it's absolutely fundamental that these are distinct individual losses which may be pursued by each person by means of their own cause of action. So they were addressed, as in paragraph 4 of their skeleton argument, as being bound up together. We certainly didn't face an argument that there was that avoided loss came first, and that none of these other interesting principles matter. And then, if you could just look, please, at the.
Are we going to? I mean, it would, and we're not going to do it. A thorough reading of the transcripts of the hearing before the judge show a number of instances in which you were each arguing what has now become the other's case.
Well,
you're not to blame for the fact that the Privy Council changes the law in the middle of the proceedings, but I mean, in the sense that you're pinning a particular submission on Mr. Hoskins, he can probably has tried to pin some on you, where you're saying the opposite to what you're now arguing in the light of what we know the law to be.
My Lord, I don't think that's right. I think we've been consistent all the way through. I think that we, as you saw yesterday, I took you to the position to the part where we sought to distinguish UCP and Nectris, although we did argue it was also wrong.
Yes.
But obviously that part of the argument's moved on. But this part of the argument, this is a new point, really. So the argument proceeded on the basis that it's all bound up together. So for avoided loss and pass on, there's no material distinction. And if you could turn as well, please, to the judgment. So we're in Core Bundle 1 behind tab 10. Page 119, please. There's a heading towards the top of the page, should the court decide these issues? And the position at the hearing was that Sir Nigel Teare was minded at the outset not to decide the issues on the basis that they may turn on facts yet to be established. And if you turn, please, to page 121, paragraph 47, I've given anxious consideration to this matter. It is the case that the skeleton argument of counsel for the defendants did not suggest that evidence of the nature which I had in mind was relevant to a determination of the issues of law. Instead, it suggested that evidence of the applicable foreign law might be relevant. And so we then see, however, it's not suggested that such articulation or disclosure is necessary before the legal issues identified by the claimants can be decided. The only point on which further evidence is said to be required is foreign law. And that's because Mr. Hoskins says, oh, well, you hadn't raised this point about collateral benefits. But that's because the whole way in which they put their argument was that there was no material distinction to be drawn between avoided loss and pass on. And in each case, what you're looking for is a cause of action on the part of the investor. And that's why, and I've just handed you up this part of the transcript, that if you can go, please, to, this is the final day.
And could you have raised inter alia acta? I mean,
well, yes, we could have raised it, but the point was that isn't how the argument progressed.
it's all about title to sue.
It was all about title to sue.
Yeah.
And if you look at, the transcript that I've just sent you, so this is day 3, and we're looking for page 75, so it's not actually page 75, but page 75, I don't think there are any overall page numbers, but if you wouldn't mind going about halfway through to find page 75 in the transcript. So if the court, does the court have that?
Again, I beg your pardon.
This is the new document.
Yes, internal page.
I don't,
No, the
afraid
little
it doesn't
page.
have
The
any
little
internal.
page.
75.
75, thank you.
75, yes.
Yes, no problem.
Okay, thank you. So this is where I stood up to reply, and I said that although the legal arguments appear at first sight to be complex ones, the disagreement between the parties can actually be boiled down to a single point. The point was described by Mr. Hoskins yesterday as being the critical issue, namely whether or not former investors have a cause of action available to them. So all of the proceedings below, all of the argument was predicated on that point. That's what we were all debating. At no point did Mr. Hoskins say, well, none of this is relevant, actually, because we've also got this other clever pleading on avoided loss, which means that we've all wasted a lot of money coming here arguing about these points.
That is one of the risks of preliminary issues stroke strike case, is that one slightly misses the key points or potentially relevant points.
My lord, I understand that, but no one was in any doubt that the point of the strikeout was because the claimants were facing extremely onerous disclosure applications, which would be very expensive if they were unnecessary.
It was a turning point in the proceedings. It was, is this going to go down this road
Yes.
or that road? I mean, this road involving mass disclosure and that road not.
My lord, precisely so. And really, the thought that we would have, the costs, the bank's costs alone for the hearing below were over £1.5 million. The idea that we would have engaged in a hearing about some academic point of law when they could turn around afterwards and say, well, none of this actually matters, even though you've won, because we've got our avoided loss argument, which requires massive disclosure, it is simply for the birds. That wasn't the basis on which anyone was operating. So I make that as a factual point about how the proceedings below evolved, and I've shown you the parts of the judgment. Certainly that was the impression the judge had, and it was the impression I had. And at no point did Mr. Hoskins or did the bank say, well, avoided loss comes first and none of this is necessary. So obviously they could have said that once faced with our application.
Well, I put it to Mr. Hoskins that I think you would have expected that when there was a strikeout of the words avoided loss, the answer to that would be, and when Mr. Justice Teare was looking at what facts to be looked at, he would say, well, there's no application to strike, no argument on that, and we are in any event going to have to look at all these documents on avoided loss. So, yes, we do have to have the evidence, because I strongly suspect that if that had been made plain to Mr. Justice Teare, he would not have gone ahead to decide this.
My lord, precisely so, because Mr. Justice Teare was I had, frankly, an uphill struggle to persuade
you
Mr.
can
Justice
read it,
Teare.
you can say he so
Yes.
nearly didn't do it even on this basis.
Exactly. So certainly, if that had been made clear, Mr. Justice Teare just wouldn't have decided it. But we say, and turning to the argument itself, so I just wanted to explain why the position we're in. But we agree with some of the observations put by Lord Justice Phillips to my learned friend in relation to the obvious consequences of the avoided loss argument if it were right. Because, of course, the avoided loss argument would apply to all tort and contract claims, not just competition law, because it's logically anterior to questions of is there a duty under Article 101? It arises first. It emerges, my learned friend says, from the principle of the compensatory principle. So it would apply to all tort and contract claims, not just competition law. And it could on no basis be limited to redemption monies paid to former shareholders. On the contrary, on the bank's arguments, whenever a lower distribution was paid to current shareholders, a lower dividend, on their argument, that would also have to be taken into account. So take and you can't say, it's not open to Mr. Hoskins at that point to say, oh, well, it doesn't because of Marex. Because at this point,
He does say that.
He does say that. Well, I'll come to that. He does say that. But take a claim, well, for present purposes, so he would have to accept, even on his argument, he would have to accept that dividends paid to former shareholders whilst they were shareholders would also come within, would also fall to be assessed for the purposes of avoided loss. Now, what Mr. Hoskins can't do, so he does say, my lord, you're right, he does say, well, the Marex principle would preclude dividends paid to current shareholders being decided. But he can't have that point both ways. So if we're right on the rule in Prudential, so it applies to former shareholders as well as current shareholders, well, then we must be right on that point.
Well, so it's circular or bootstraps.
It's circular or bootstrap. So he's conceding by saying the avoided loss principle doesn't apply to current shareholders. He's conceding that to analyse the bounds of the avoided loss principle, you have to look at the rule in Prudential. Well, we actually agree with that. It's the first point of principle I made yesterday. We agree that if you approach avoided loss in this way, in the way that the banks contend, you're completely undermining the rule in Prudential. So we agree that whether or not you can run the avoided loss point depends on the scope of the rule in Prudential. And so we say that if we're right, that the rule in Prudential, that Primeo is correct and Primeo can't be distinguished, then we say they have no avoided loss argument, because those very important rules, that very important rule in company law and in trusts and in partnership law, would be undermined. And what Mr. Hoskins is trying to do is trying to have the point both ways. So he's trying to say, well, we can rely on the Prudential rule to get rid of avoided loss for current shareholders, because we can see that that's very unattractive and would lead to lots of problems. But it doesn't address the problem of former shareholders. So take a claim by a company in negligence against a solicitor's firm, for example. Marex, the rule in Prudential says that shareholders would not have their own claim. But we say that if the banks are right on their avoided loss argument, the court, in considering the company's claim in negligence against the solicitors, would have to examine all of the company's actions vis-à-vis its shareholders in light of its reduced profits caused by the tort. So it'd have to determine, for example, whether the company paid lower dividends as a result of reduced profits, and if so, by what extent, whether it didn't pay dividends when it otherwise would have done but for the negligence, if the company had made provision for the redemption of shares by its shareholders.
Just what we would call a massive counterfactual.
Yes, but a massive counterfactual which, crucially, lifts the veil that's established by Marex. And I'd just like to have a look at Sainsbury, because my learned friend placed some weight on Sainsbury's. And that's in Authorities Bundle 4, behind tab 42. And he placed weight on paragraph 205 in particular. So let's have a look at that. So that's at page 1259. So if the court has that, you see at letter C.
Sorry, forgive me, I've got the wrong.
Oh, I'm so sorry. So we're in Authorities Bundle 4, behind tab 42,
Yes.
page 1259 of the bundle.
1, 2. Thank you.
And it's paragraph 205. And Mr. Hoskins took you to this paragraph where the Supreme Court was looking at what the merchants could have done or might have done as a result, or when they paid the overcharge in the MSC to the acquiring banks. And there are 4 principal options, the court said. So 1, a merchant can do nothing in response to the increased cost and thereby suffer a corresponding reduction of profits or an enhanced loss. And Mr. Hoskins said, well, we're within number 4 here, which is the merchant can pass on the cost by increasing the prices which it charges to its customers. But in my submission, we're not within number 4. We're not within category 4. Because there is no, on this avoided loss argument, there is no pass on. The company isn't taking some action to pass on any overcharge or any loss that it suffered. We're actually squarely within the first category. We're looking at reduced profits. And no, it's true that the Supreme Court was not addressing the issue before this court, but neither did it say in relation to 1, well, you can't simply take at face value the reduced profits, because then you've got to look at what the company might have done vis-à-vis its shareholders following those reduced profits. So what does a company do when it has reduced profits? Well, it pays lower dividends.
Or lower redemption.
Or lower redemptions. So here we say, if anything, I don't want to derive too much from this authority, because plainly the Supreme Court was not grappling with the point in issue in this case. But we say it supports us in principle, because what the Supreme Court held, if you look further down the paragraph just above letter E, is that if the merchant were to adopt only option 1 or option 2 or a combination of them, its loss would be measured by the funds which it paid out on the overcharge. It doesn't go on to say, oh, well, actually, reduced profits by itself isn't a measure of loss, because you've then got to start analysing whether Sainsbury's paid lower dividends to its shareholders or allowed shareholders to redeem their shares at a lower value. It doesn't say that at all, and that's what it would need to say in order for this case to help them. So why are the banks wrong on avoided loss? They're wrong in our submission for two reasons. The first reason I've canvassed already, and it is that the law considers that there is an economic unity between company and shareholder and trusts and beneficiaries. And we saw that very explicitly addressed in Marex. An example, let's just pull up Marex, please. So, Authorities 5.
Sorry, just, you're saying there are two reasons.
Yes.
What are the two reasons? What are the two reasons?
The two reasons are that there's a reason of principle, which is the one which I've canvassed already, which I'm going to elaborate on.
Are you able to just state it? Give me something to write down, would you? What is?
So sorry, my lord.
What are the two reasons?
That it's undermining, in principle, of the fundamental rules of English law that we've been discussing, including the rule in prudential.
Yes.
And the second reason is that even if these matters fall to be assessed under the rubric of avoided loss, they're plainly collateral, even on the assumed facts, and there's no need to find further facts. So those are my two reasons.
Thank you.
So in relation to the first reason, if we could briefly turn up Marex again and look at page 1295. And paragraph 36, isn't it? I just want to show you this by way of example, but you've seen Marex now enough to see that the judgments are replete with reference to this underlying rationale. But we see at paragraph 36 the idea of economic unity between company and shareholders. Sorry, paragraph 37. And so to tease this point out a little bit further, Mr. Hoskins seeks to draw a distinction in this case between current and former shareholders. So he says, oh, well, that's all very well, but that really applies to current shareholders. But, and he says that, he does that because he recognises that Prudential and Marex at least goes that far. But if he's right on avoided loss, then you don't get into those principles at all. Equally, the distinction between current and former shareholders is irrelevant in this context. And what we say is that really underlines our point that these matters don't arise under the rubric of avoided loss at all, as a matter of principle, because if they did arise under the rubric of avoided loss, and if the court had to examine whether or not profits, which Sainsbury's has held is the prima facie measure of loss, or is a measure of loss which is recoverable, have to be investigated further, reduced profits, because of these interactions between the company and shareholders and former shareholders, that would, we say, directly undermine the very fundamental rules of English law. That's what those rules are there to prevent. So if we're right on the rule in prudential and we're right on primeo, then we say as a matter of principle, these arguments do not run under the avoided loss head. So that's our first point. And we say, secondly, even if, as a matter of principle, even if we're wrong on that, so even if they do fall to be assessed under the rubric of avoided loss, we say that these matters are plainly collateral on the assumed facts, and there don't need to be any other further findings of fact. And it's very important in our submission to identify what were the facts that Mr. Hoskins said this morning would need to be established at trial in order to consider this point about collateral benefits. And his point, he said, his point was that the banks would seek to argue that benefits to the company on redemption would not be collateral because the reduced payments to former investors would be directly linked to the wrongdoing. He said that's what the bank's argument would be. And he said, well, if the funds were to dispute that, if they were to dispute that wrongdoing caused lower redemption payments, then the facts would need to be established to determine whether that's right or wrong. But the point is that this is an assumed fact in this appeal, as Mr. Hoskins said several times. So it's an assumed fact in this appeal that the wrongdoing led to lower redemption monies. So the court can assume that and should assume that for the purposes of this appeal. And so there are no further findings of fact that need to be made. The question really is one of law. So that's the bank's case. Mr. Hoskins hasn't pointed to any other facts that would need to be determined. And as a matter of law, are those benefits collateral or are they not? And we say that, that they are collateral. And we say that, they're similar. So in the same way that the courts now could determine that, for example, gifts following a personal injury or payments made under indemnity insurance or disability pensions are collateral and are not to be taken as reducing the loss claimed. We say that this point too can be treated in the same way. And the reason for that is that the benefit arises from a legal relationship between the claimant and a third party, the investors, which is independent from the tort. So it arises from the relationship between the funds and the investors. Because it's the relationship between the funds and the investors that determines that point. It's that relationship. And that's precisely the point that the Australian court grappled with in Young and Murphy. And importantly, the Australian court grappled with that point without needing to construe the trust documents or to look at any of the surrounding facts.
So when all of these authorities were dealing with sales to third parties but not redemptions, you say it's a distinction without a difference.
So sorry, my lord, can you repeat that?
Yeah, Mr. Hoskins took us to the case and said, well, this doesn't apply because it wasn't a redemption in that case, it was a sale to a third party.
Yes.
Your case is that that's a distinction without a difference.
Exactly. Yeah. So in Young and Murphy, so is my lord talking about the Young and Murphy?
Well, it was that set me off, but I mean, if I've got the wrong case, I apologise.
So the point that was Mr. Hoskins' attempt to distinguish Young and Murphy really doesn't stand up to any scrutiny at all, because he really had no response to the analysis in Young and Murphy. What he said, he sought to distinguish it on the basis that in that case, the trustee had not alleged that any individual loss had been caused.
We haven't identified a unit loss, a separate loss.
Well, he said that no, he took you to the pleading of the trustee. So it was the new trustee that was advancing the claim. And he said, look, here's the summary of the pleading of the new trustee. The claimant doesn't allege here that any individual loss has been caused to the beneficiaries. That was his point of distinction. But precisely, of course, this is true in the present case, because my clients are not alleging that either. So my clients are not alleging that any individual loss has been caused to the beneficiaries. There's no point of distinction between that case and this. It's the banks, of course, that allege it in support of their case, that the trustee doesn't have title to sue, just as the defendants alleged it in Young and Murphy. So it's exactly the same. And the court in Young and Murphy disposed of that argument, we say, for the right reasons. And what Mr. Hoskins didn't do was take you to the court's disposal of those arguments. And we say, well, that's presumably because he doesn't have any good answer to that part of the judgment. So that case can't be distinguished. And we say that the court in that case got it right, because what the court was saying, there is no link here. These are collateral benefits because it's all to do with the relationship, the internal trustees, the internal relationship between the trustee and the beneficiaries. The court said in terms, it doesn't matter that the identity of the beneficiaries are changing. It doesn't actually matter what the trustees say. They may say that that any recovery by the trustee is to be given to ex beneficiaries, or they may not say that. But either way, that's a matter for internal the internal relationship between the trustee and the beneficiaries. It's not a matter in which the defendant is interested, in which the defendant is interested, and that's the reason why any benefits, in inverted commas, are collateral. So we say that.
Is there a possibly bigger point in relation to the redemption argument, which is that when you assess a fund's loss, if you look at redemptions, you could say from the start, well, this fund, all this fund ever has to do is ultimately pay its investors out on a NAV basis. So from the very start, you can say that it doesn't matter what damage is done to their assets, the fund in that sense won't suffer any loss because it has a corresponding benefit. And you can almost define away a fund ever suffering any loss because all that happens is there's a corresponding diminution in the amount it has to pay to its investors. Particularly if it's a term limited fund, you could say that within X period, it's going to give all its assets back to its investors.
My lord, exactly so, and I think that's a better way, if I may say so, of putting the point which I've been trying to make in relation to there not being a principal distinction between current beneficiaries and ex-beneficiaries. It's really the other side of that coin, and that's why we say if you treat all of this as avoided loss, what you're doing really is obliterating those fundamental rules of English law. Because
I'm not sure I'm that keen on the distinction, the formulation current and former, because both those who sell and those who redeem, at the point at which they do that, they are current shareholders. They don't become former shareholders until
they're current at the relevant times.
They're current at the time they sell and current at the time they redeem. So it's only former in a sense that by the time they're suing, they are former, but they are actually suffering the loss qua current shareholder. Reaping the economic consequences of being a shareholder of a company or trust that has suffered a loss.
My lord, we entirely agree, which is why we say that. So it's really my learned friend that seeks to make this distinction because he recognises that the cases he needs to do that really because of the fundamental principles of law that we have in English law. But we respectfully agree with the point that you've put to me. And that's why we say it's simply wrong to say that there's some distinct loss that arises later on redemption. It's just not, it's not correct as a matter of principle. The loss is the loss that was suffered when they were current shareholders. And that's really what the Privy Council in Primeo were recognising when they looked directly at the case of sale of shares. They were saying, well, when the loss was suffered, it was that's why they said this is a rule of substance, and one has to look at the substance of it, of the loss, and the capacity in which the loss was suffered. And the substance of the loss and the capacity in which it was suffered at the time that the company suffered loss, these, as you say, were all current shareholders at that point. So the capacity in which they suffered the loss was qua shareholder.
Well, they presumably had to give notice of redemption.
Subject to the terms of yes.
So there's going to be a period in which you have bound yourself to redeem at a particular value, for which you will be a current investor. Ditto, a shareholder will contract to sell his shares, but the settlement date will usually be at a future time. So they also will be a current shareholder with a contract to sell at a loss.
Yes, and so of course what the banks need to say is, well, that doesn't matter either. What really matters is when it all goes through at the moment they become an ex-shareholder, then it's all different, because at that stage...
But by the time they've entered the contract, they've crystallised their loss.
That's another way of looking at it, my lord, and that's why we say, looking at it that way, I think shows the vulnerability of the bank's argument. I mean, we say, of course, that one is looking at the loss when it was suffered by the company, and you ask yourself then, well, the shareholders, what loss did the shareholders suffer? They lost the loss in inverted commas they suffered was qua shareholder, and is not recognised as being distinct and separate. Now, what my learned friend seeks to say is, oh no, it matters when the ex-shareholder suffered the loss, when the particular claimant suffered the loss. But that, in a sense, assumes what it needs to prove, that there is a separate loss. And we say that that argument is simply inconsistent with the Privy Council's judgment. The Privy Council wouldn't have held that UCP and Nectris were wrong if it could be the case that, that a shareholder, once the sale had gone through, could say, aha, now I didn't have a loss, but now I do have one. They simply wouldn't have decided that UCP and Nectris was wrong if that's what they thought. So one can't get round Primeo by saying, well, the relevant date is when this particular ex-shareholder suffered loss and they're now an ex-shareholder, because it does, in our respectful submission, assume what it needs to prove. So those are my submissions really on company, submissions in reply on, there was one point actually on redemptions, and Mr. Hoskins took you to provisions of the Companies Act. And in relation to that, we respectfully agree with the observations of Lord Justice Phillips that it really has to be determined as a matter of substance. So it comes back to the substantive question of what did Lord Reid intend by this. And I took you in opening to the paragraphs which showed that he intended to mean by distributions, not just dividends, but a wider category of payment. And I took you in particular to paragraph 61, where he said that in terms, and also to the paragraph which showed that he had in mind payments on winding up of the company. So, those are my submissions on company law, trusts and partnership. I can deal with Article 101 very briefly. I don't know whether you want me to press on. It's not going to take me very long, or whether there's an urgent need for a break.
We'll have a 5-minute break. Thank you. No. Hold on. I was going to say, good to know how much it is.
going to go to Monaco, sorry, because I've got it open.
It says the indirect point he accepted on the basis of that judgment. So you even indirectly accepted an indirect point as possible.
Welcome. No, no, it's not as much American rule in London.
What row is that?
41. And then he said, I see 42. That you might have effective rejection. Supremacy.
Yeah.
You also accepted any general concerns in the law set aside for the national law.
I'm just going to I want to go to Monaco to Hamlet.
So then go to Monaco. You then went to get equivalence and effect of statutory general protection on the basis of this
To stand up and say, very good.
Exactly. So this whole case is collapsed. Because
Right,
of
okay, and then
impact. So then I go to impact and measure.
We're still being streamed to the world. Colin looked at me, say something terrible.
Colin's a little bag of it right there.
It's funny, I didn't know that.
Wearing my dad's clothes. My dad's clothes when I'm a child.
It was a false alarm.
The whole point is that they just maintain after that. No factual suggestion that the money recovered and the reputation.
All business as usual.
It turns out
Yeah.
who knew?
Can only be right.
How long have you had it?
Honestly, also the Willis as well. Absolutely make it. I think it's my
And then just to make it
certainly not in this instance. No, that's it, isn't it? Yeah. No.
Yeah.
that point is dispositive of this issue.
Where is the notes? So let's go to that as well. Where are they?
I was a white screen job.
So that's it.
So they give examples and proportionality and retroactivity. The point is that
I know it's
if you go to the act,
no, it's right. I don't need to do this. I can just say.
yeah, but the act basically says that you recognise justice for completion. What?
I mean, I think it's
Effective protection. It's not legal service. Yeah, exactly.
right. So I don't need to do
Yeah,
this.
you don't need to go through
I don't need to. Thank you.
That's also. Yeah. I agree that I still think I get credit. Yeah, yeah. Well, absolutely. told us.
But this is a really good thing.
Yeah, yeah. You know, you'll take it right. It does require a bit of like,
Oh, God. It's easy.
well, it's straightforward, isn't it? In the sense that it's been, yeah, it's not much. You don't need to do it for 6 years. Is that okay? Interesting, not isn't it? They did preserve 15 documents. That's probably all okay. I know. Yeah. It just really. Yeah, I won't physically in chambers. In terms of what I did, so it would be really useful to talk to you. I don't have any experience really developed plans, but I do have some suggestions. No one's been put on NPTF already yet. Yeah, well, we have any time, right? We're the best one we have. There's loads of application to be fair. And yeah. But to be fair, I think that there's probably quite a bit of stuff that you need to read, even to
Exactly. That's what
into witness statement, background, the advice.
all the different notes. So that's what
Yeah, no, that's not. I would also like to talk about what level of granularity. I get it. We'll get a lot in a reshoot to put together, kind of put some documents and the notes and stuff. But so the actual work. Because I've got some thoughts on it, but you know, I'd like to check before I get into it. A reshoot also got to do with chronology, which is going to be a massive bit of work. But I think will be really useful for you. It will take quite a lot of time. You know, to fill in all the gaps, right? So most times. Which I do think is a brilliant idea. It was my own. I think it's a brilliant idea. I think it will be very useful to reason it. There you go. I just give. It's one of those presents of work. Yeah, absolutely. Yeah, but that doesn't involve and then there's I've got lots of ideas, but wait, surprise you to hear. But then I need to talk to you about how Lords, my lady, Mr. Hoskins took you first to Unibet, and can I just ask you to turn that up again, please? So we're in Authorities Bundle 6, tab 56, page 1661. And he took you to, he showed you that in general, in principle, it's for national law to determine an individual's standing and legal interest in bringing proceedings. But he showed you, so if we look at paragraph 41, please, of the judgment at the bottom of the page.
Yes.
He placed emphasis on paragraph 41, and then he showed you paragraph 42. Whilst in principle for national law to determine an individual's standing and legal interest in bringing proceedings, community law nevertheless requires that national legislation doesn't undermine the right to effective judicial protection. And he going back, so he relied on the principle of effective judicial protection. He said, well, that's a different principle to the principle of effectiveness and the principle of equivalence, which we see in paragraph 43. And he also said, going back to paragraph 41, in relation to current shareholders, that if national law provides an indirect remedy, then that's adequate for community law purposes. But really we say that that in conceding that an indirect remedy may be sufficient, Mr. Hoskins has really conceded that their primary argument, that any individual must have a right to claim damages in national courts, he's really conceded that that's wrong. And this concession that even an indirect claim might be sufficient is a new point that wasn't made by Sir Nigel before Sir Nigel Teare. But in any event, we don't complain about that, but we do say that it's important because it demonstrates that they now accept that the references to any individual and so on can't mean that any individual has to have a claim.
Why doesn't indirect remedy cover the fact that the shareholder is compensated indirectly in relation to any diminution in value by the company's claim?
So they may or may not be, my lady, is my response to that. So they may or may not be compensated directly. So if indirectly,
Yeah.
they may or may not be. So if for example a derivative action is brought, there may be creditors that are in line first,
Yes.
and so they may not actually receive any of the money. So they may or may not be protected. And also a similar point could be made in relation to the judgment of the Irish Supreme Court. So Mr. Hoskins said in relation to that, well, here there was an indirect remedy because of the unfair prejudice petition. But of course, there's no suggestion in the facts of that case anywhere that that remedy was sufficient to compensate the claimant for the loss caused by Article 101, Article 85 as it then was. Indeed, the fact that this second claim was brought might indicate that it wasn't. So really, we say that point doesn't carry them very far. Mr. Hoskins then turned to the Monocar case, and that's behind, if we can look at that again, so that's behind tab 58 of the same bundle, page 1779. And he took you to, I think it was paragraphs 48 and 49. And so they say again that it's for the domestic legal system to lay down the rules governing remedies, if I may put it like that. However, the member states are responsible for ensuring that those rights are effectively protected in each case. See impact. I'll come on to impact. Thus, whilst it's in principle for national law to determine an individual's standing and legal interest, community law nevertheless requires, in addition to observance of the principles of equivalence and effectiveness, that the national legislation does not undermine the right to effective judicial protection. And it was that latter point, the right to effective judicial protection, on which Mr. Hoskins places weight. So he says, well, that's an aspect of supremacy, which is where he gets to all of this surviving Brexit. But if we turn to Monocar, to impact, please, so behind tab 57, page 1722. Now, Mr. Hoskins took you to to paragraphs 44 and onwards, but could I just please ask you to look at paragraph 43? Because that says that it's important to note that the principle of effective judicial protection is a general principle of community law. And so the point about effective judicial protection is that it doesn't assist Mr. Hoskins at all, because it's one of the general principles of community law. And it's common ground that the general principles of community law do not survive Brexit. So our interpretation of the Act, we're ad idem on the interpretation of the Act.
So I thought that was his position as well.
It is his position
Yes.
as well. So it's common ground. So he has to rely on the principle of supremacy. And so his submission was, well, the general principles, the principle of effectiveness and the principle of equivalence, they're general principles. So he accepts they don't survive. But the principle of effective judicial protection, well, that's all about supremacy. But here's the European Court saying, well, it's a general principle of EU law. And the explanatory notes don't help because, yes, they refer to effectiveness, the principle of effectiveness and equivalence, but they say those are examples of the general principles. So this really is dispositive of the point. And of course, you have my point already, and I'm not going to labour it, that really the position of, if Mr. Hoskins, for Mr. Hoskins to be correct about the meaning of Article 101, he has to show, really, that any individual that's factually suffered a loss has a right of action. And we say, first of all, he's conceded, on the terms of his own argument, that that isn't correct. And we say that, that secondly, it's simply wrong in principle. And he has to be right. He can't distinguish between sales to a third party or redemptions, because as a matter of fact, trying to look at it through the perspective, through the prism of EU law, both of those, the shareholder in both of those situations has suffered a loss. So he can't, on the basis of these authorities, establish that EU law requires a cause of action or a right of action to be accorded to the redeeming shareholder and not to the selling shareholder. It's simply unsustainable on the basis of these authorities. Unless the court has any questions for me, those are my submissions in reply. I think I hopefully made clear our primary arguments in opening. I don't want to repeat any of those.
No. I do want to ask you something, and having done that, if I may, I'll trouble Mr. Hoskins to deal with the same point. Could we look together, please, at paragraph 9 of the judgment? Core 112. Now, that's where the judge conveniently sets out the, as it were, the battleground.
Yes.
And I think we're looking, are we not, for practical purposes, at 15, 16 and 17, which are then replicated with regard to other forms of funds later on in the pleading,
Yes.
but these stand for the argument that was being raised. And so what I would like to do, please, but not at undue length, but just so that I fully understood this, is just to understand what you both say about the procedural sequence of events that has occurred in this case, which has been slightly unusual because of the interposition of decisions taken elsewhere in the course of the proceedings. So I'd just like to follow this through with you, if I may, to make sure that I've understood it.
Yes.
The banks start by drawing a line with reference to what they describe as former investors. If we look at these paragraphs.
Yes.
You look doubtful.
No,
Isn't that what these, if we look at the top, redemptions or withdrawals?
Yes.
And these are former investors who have redeemed.
That's right.
Redeeming former investors as they describe it.
Yes.
We had an interesting discussion about whether the term former investor is a useful...
My lord, yes.
But anyhow, that's how these paragraphs are framed, and you are going to have to give credit for loss that the funds may have avoided or passed on.
Yes.
In respect of those individuals. So I trust I encapsulate the argument with which you were faced.
Yes.
Faced with that argument, the procedural step was not, for example, to ask for a trial of an issue.
No.
It could have been.
A preliminary issue with disclosure and so on. No, we didn't ask for that.
No, not a preliminary issue with disclosure, but a preliminary issue on the basis, a question of law on the basis of assumed facts. I mean, would it have been open to the court to say, right, well, there's an interesting point, either it's right or it's wrong, we can try this as a preliminary issue so that certain consequences flow if yes, if certain consequences flow if no. So could that have been dealt with as a preliminary issue?
Well, I think in principle, my lord, it could have been dealt with as a preliminary issue.
Yeah, I'm not being critical of anybody that it wasn't.
No.
I'm just asking, you know, with taking advantage of your expertise to understand what might have happened in this case, but it didn't in fact, because you applied to strike it out.
Yes.
Right. Having applied to strike it out, as I understand it, it boiled down to one argument, which is that can't be right because these individuals wouldn't have title to sue.
Yes.
So, again, at the risk of great oversimplification, the strikeout went forward and everybody agreed in the round, it would seem, I'm not foreclosing on Mr. Hoskins' argument, but it looked as if everybody was saying, well, this all turns on the question of title to sue.
Yes.
And so everybody applied themselves to that question, and the judge reached a conclusion. And one of the things we'll have to decide on this appeal is whether he was right or wrong in that conclusion on that issue.
Yes.
Right. Now on this appeal, there having been developments legally since that argument took place, another issue arises, the question of avoided loss and collateral. So what I want to understand is what you say would happen, and I'm particularly interested to hear what Mr. Hoskins also says about this, if we were with you on the question of title. I'm putting that entirely hypothetically. What happens to the proceedings and to the pleading if we're with you on the question of title? What happens about the other argument, the question about collateral? Where are the proceedings left if the appeal is simply dealt with on the basis of the ground rules that the parties applied to themselves and that the court accepted below?
I think that the answer to my Lord's question is first of all, of course, we contend that the court can and should deal with the avoided loss plea as a matter of law for the reasons that I've given, for the two reasons that I've given. One is that it's wrong in principle, and second, there are no further facts which Mr. Hoskins has pointed to which need to be determined other than the assumed fact in this case. So my first answer is that. And the second answer, I think, is that if you're against me on that, then as a matter of fact, there will be a subsisting pleading, but there will be a question as to whether or not the banks are entitled to pursue that pleading or whether it should be struck out, because we say the point was conceded below, and if it's now going to be said, well, it turns on facts, and if the court so finds that it turns on facts, then there'll be a question as to whether or not the concession should be withdrawn. There's obviously case law on that. It's a question that I would respectfully contend is a question for another day.
Right. Well, unless either my lady or my lord wish to ask any further question about that.
So did you want to hear from me?
I do. I just was checking that we finished. All right, Mr. Hoskins, I should in fairness have asked you this when you were on your feet, but I hope it doesn't put you in difficulties to deal with it now.
So my submission is that in the circumstances you've described, the relevant paragraphs of the voluntary particulars, i.e. those relating to avoided loss, would not be struck out.
And which, are we looking at 15, 16, 17 as examples of that,
Indeed.
ones that the judge chose?
Indeed. So the it would run to that investment fund will have avoided all or part of its loss. And I'm assuming if you're against me on everything else, that would fall. I've got submissions about pass on and right to sue, so it's not quite as simple as that. But if we're focusing on avoided loss, the plea in relation to avoided loss would stay. It would be a live issue in the case.
I'm sorry to take it at such a slow pace, but I just want to make sure I've understood every argument. Let's suppose, solely for the sake of this argument, that we say, yes, the funds are right and the judge was wrong, no doubt with the benefit of later authority and so forth, on the question of title to sue. Right. So how does that conclusion sound, if at all, in relation to the pleadings that we're looking at on the page? Or is it completely a footnote in history?
The only reason I'm hesitating is because in order to decide, for example, if the company has avoided loss, you have to, as a matter of law, decide what is the company's loss and what is someone else's loss. And the only place one finds assistance on that question is in the case law on reflective loss, etc. So I think it'd be odd to imagine this case coming to the court and being argued here or below without looking at Marex, etc., and Promeo, I can't really imagine how it would have been done in that vacuum. And that's why I'm hesitating when you ask me the question you've just done, because I don't think, even if the matter had come up purely as an avoided loss point, we would not have gone into all the cases we have in fact gone into before Mr. Justice Teare, albeit, as has come out of the exchange, there is now this issue which is avoided loss is still relevant, even if no third party has a right to sue. So I'm sorry, that's a bit convoluted, but I hope...
I'm not trying to, as it were, in a sense, pin you down or limit any reasonable arguments that you might have on another day about anything, but I think that we, having looked at the issue on which the case came up and the issue which you fought out and reached a conclusion about that, and having regard to the fact that we've also heard argument now about the avoided loss and collateral issues, we will have to make a decision as to the extent to which we deal with that issue.
Absolutely, yes.
But one of the consequences of this appeal must surely be that we leave the case in a condition that the judge who will then take it up knows what they are dealing with and on what basis. And so it seems I'm getting the impression to be common ground that it simply wouldn't be a proper way of dealing with the matter for simply to deal with the single issue that just decided the matter below that has been argued fully before us, and we reach a conclusion about that. And then just simply say, and the appeal is allowed or the appeal is dismissed, leaving everybody to wonder what that means and what arguments are open and what arguments are not open, what we've decided, what we haven't decided. That would be, it seems to me, a grave failure of the system and put a judge into an impossible position. And so that's why, in a sense, I haven't quite understood what you say follows from a hypothetical position in which your argument has not succeeded on the title point, and where that leaves the court and the parties. Because if you're saying, well, really it just means that our particulars stand, they will need a lot of explanation as to what they stand for and what's open and what's not open. And
understand. So I think, I can't pretend this is encyclopedic, I'm sorry, after 2 days. I think at the very least, on the premise you've described, the avoided loss principle, the avoided loss pleading would stand.
Right. And if it would stand. And so therefore we, again, tell me if you're not accepting this, we really are in all conscience obliged to deal with that point, either to say we can deal with it because there are no new facts that are going to be needed, or the banks are right, we can't deal with it for the reasons that you've given us.
Yes.
And remit it, or at least send it to the commercial court so that it can then get on and carry out whatever exercise follows.
I'm not. Sorry.
No, I thought your position on, let's call it Lim 2. So Lim 1 is title to sue. Lim 2, avoided loss. You invite us to deal with all of the arguments we've heard, with the exception of res inter alios. I got that wrong. I thought that was where you drew the line. You said that's something we can't deal with.
Exactly. I say you can't.
Because there's much more to dig and discover and la-di-da.
So that's the point.
But the avoided, there are two bits to avoided loss.
Yes.
There are bits of avoided loss that don't turn on res inter alios, that sort of, as Dimitri has put in reply very helpfully. So we can deal with all the avoided loss points with the exception of collateral benefit.
Yes, I say you can't finally decide avoided loss, and that's why I say that bit of the pleading would stand on this basis, because it can't be finally determined for the reasons you've described.
That's your position.
Yes, and just as in practical terms, does the pleading as it stands at the moment reflect that, or would it need some work in order to explain what was left? In other words, would there need to be surgery if your argument succeeded on those paragraphs?
Well, I think it would be blue pencil rather than redrafting.
All you would do, you would say that if claimants, the appellants, are successful, all that would happen is the words "or alternatively passed on all or part of its loss."
I think that's right.
Be struck out.
I think that's right.
Plus I think you'd have to accept 16 would be struck out.
Well, except it refers to avoided.
No, but that's the question of standing to sue.
16 is different.
Which is
Yes, I understand. So it would. I don't think if 16 was struck out, but 15 survived in the way you've described it, I don't think anything
so
would turn on.
all of this before Mr. Justice Teare and before us will all be just about striking out that alternative allegation.
That's where it might come down to, because you know the history. You have the submissions on why we are where we are. Promeo happened between Mr.
Yes.
Justice Teare and this, and that has implications for the way in which the case
It's
is
a
argued.
particular characteristic of the
Yes.
of the- Very well. Well, that's certainly speaking for myself. That's been very
Thank
helpful because I mean, clearly we'll have to now consider our decisions about these matters, and we'll let you have them in the usual way for the usual purposes. There'll be a certain amount of work will be needed then on drafting the orders. But I didn't want the situation to be simply that we reached particular conclusions and then asked you to go away and deal with the consequences without any consideration of what they might be. I think we'll need to do a certain amount of work on what the ramifications are before we ask you to carry out your own tasks. The hope is obviously that you'll be able to agree with the consequential matters, and if you can't, then you'll receive very short submissions and decide them on. And the hand down will, I'm afraid, probably be electronic as usual without the need to trouble you further. Anyhow, thank you to advocates and those who support them. It's been an interesting hearing.
Thank you very much. Thank you.